Yes, probably so. Anytime you raise capital from passive investors who are expecting to earn a profit from your efforts, you're likely talking about the offer and sale of a security. Securities offerings are regulated by both federal and state law, and the penalties for violating the securities laws can be pretty severe. So if you're raising capital, you want to understand what you're doing and make securities compliance a top priority. Regulation D is a series of 3 safe harbor exemptions from the registration requirements for securities offering. It's been around since 1982, and it's a great tool for entrepreneurs and real estate sponsors to raise capital without having to go through the lengthy and very expensive process of registering an offering with the Securities and Exchange Commission. Rule 501A of Regulation D defines 8 categories of accredited investor. For individual investors, we're typically looking at 2 categories, one based on net worth and one based on annual income. So if you have a net worth in excess of $1 million, not including the value of your primary residence, or if you have annual income in excess of $200,000 or $300,000 a year jointly with your spouse, then you're an accredited investor. This is important because most Regulation D private placements are only open to accredited investors. So whether you are a sponsor putting together a Reg D offering or you're an investor looking for alternative investment opportunities, you need to understand the accredited investor concept. Thanks in part to a federal law that was passed in 1996, Rule 506 became far and away the most popular of the 3 Reg D exemptions. Under a Rule 506 offering, you can raise an unlimited amount of money, you can offer and sell to an unlimited number of accredited investors, and if you limit your offering to accredited investors, which is a good idea for a variety of reasons, there are no specific disclosure requirements to satisfy under Regulation D.